Morning, everybody. We're going to make a start dead on 11:30. So if you want to get comfortable, get yourself a drink. If you want to pop in the question box where you are dialing in from, where you're watching from today, we'll try and do a couple of shout outs as well, but we will make a start dead on 11:30. Okay, good morning, everybody. Welcome to today's webinar, which is about employment law updates, BrightHR's top 10 tips for success. It's great to see so many people on today. If you do have any questions for us during today's session, then pop it in the Q&A box. And if you want to drop a line as well, just where you're messaging from, that'd be great. We recognize in this session that employment law is continuously changing, and it can make it really difficult for small businesses to navigate through the landscape of employment legislation. During today's session, we will cover some fundamentals of HR and employment law, trying to break it down a little bit for you so that you leave the session with a better understanding of how to boost things like HR strategies, your approach to working with your employees. So let's get started. First of all, just the usual reminder, this information contained within the session is based on Great Britain and Northern Ireland legislation. So if you are tuning in from Jersey, Guernsey, Republic of Ireland, or the Isle of Man, then you should seek advice relevant to your jurisdiction. There's a lot of useful content in today's session as well, so do stick around for that if you are dialing in from any of those other jurisdiction areas. And if you do want further information on any of the reports or statistics that we run through as part of the session, then do let us know in the Q&A box and we can follow that up afterwards as well. Some quick introductions. I'm Warren O'Donovan. I look after the Bright advice team here in Manchester. It's very grey today, as you would expect in Manchester. This is our summer. I've worked for Bright for almost 12 months. I've worked for the group for 6 years, and my team deal with all the employment law queries that come through from our clients. So everything from onboarding, probation reviews, conduct, disciplinaries, grievances, GP redundancies, capability issues, everything, you name it, we are that helpful helpline. We're available 24/7, 365 days a year to support our clients and walk them through the steps they need to go through to remain compliant. I'm joined today by my colleague, Lucy. Lucy, do you just want to introduce yourself?
Yeah, of course. Hi, everyone. As Warren said, my name's Lucy. I've worked for the company for just over 5 years now in BrightHR in the Manchester office. I am basically like an internal coach, so I just make sure that everyone's knowledge is as good as it can be in terms of the software that we provide to our clients. So then that when you call up or you have an onboard with us in for training, again, you are getting the best knowledge that you can. I also just wanted to mention that in the background we have Emily and Amelia. You most likely won't hear from them, fingers crossed anyway. They're mainly for me and Warren for any tech support that we might need. But that is all from me for now. I'll pop you back onto Warren.
Brilliant. Thanks, Lucy. So what we're going to cover in today's session is a top 10. So looking at employment contracts, first of all, which is our number one. Number two is health and safety considerations and some general information there. Policies and procedures, what to look out for, what you probably need to review over the next 12, 24 months on policies, things that are changing, things that are coming in. A little bit on compensation and pay, national minimum wage. Some employment law updates, we're going to look at holiday entitlement. Working time regulations, we're going to cover in 7. Pre-employment checks as well, we're going to look at a little bit. We get a few queries on the advice line with regards to references, DBS checks, what to do in certain situations. Ending employment, obviously a key one for us on the advice line if somebody isn't performing or you're making somebody redundant. And then finally, dealing with workplace conflict, as we have seen an increase in kinds of queries coming through with regards to grievances in the workplace. Office banter is something we've seen an increase of this year. Harassment claims as well, and bullying claims have started to come through a lot more now as well. So let's get started. So first of all, employment contracts. So all employees have an employment contract with their employer, and a contract is an agreement that sets out the conditions, the rights, the responsibilities and duties, and both parties should stick to that contract until it ends. So a contract will end either by resignation of the employee or a dismissal by the employer. And as soon as somebody accepts a job offer, then they have a contract with that employer. There was a case previously, McCann versus Snowzone, where Snowzone had used an agency. They had interviewed McCann. They offered him verbally the position. They didn't discuss salary. They didn't discuss any terms or anything, but offered the job to him. They then interviewed further on in the week. They decided to have somebody else instead. Somebody else had performed better in the interview. And then they just decided to tell him that they weren't going to offer him the job anymore and they were going to pull it. He actually took that to tribunal at the time, and he was awarded a month's salary, which was 3,000, just over £3,000. And he was awarded that because that's what would have been in his contract had he been sent that contract. So it was a month from day one. And so that's what the tribunal decided he should be reimbursed with. So definitely check your wording in your offer letters with regards to notice. Statutory notice under a month is 0, so I would probably push for that. And making sure that if you are going to make any verbal offers, make sure that you are confident that you are going to be offering that person, you've seen all your candidates, and that person is the person you want to offer. Always good to make sure that the offer is in writing as well, always best practice to do that. Contract terms. So an employer should clarify which parts of the contract are legally binding, which is known as terms. Implied terms are those which are not specifically agreed between employer and employee. So things like not stealing is pretty much a given. Providing a safe environment is a given as well. Other things that we see with regards to employment contracts, collective agreements as well. So an employer may have an agreement with employees' reps, so trade unions, that allows negotiation in terms of conditions, pay, hours of work, if you want to change roles, things like that. A written statement of employment is the document which states the conditions of the employment, and we've got to provide that by the first day of employment, and a wider written statement within 2 months. Always best to do all that onboarding admin in that first week, I would say. So your payroll forms, your next of kin forms, your induction processes, getting handbooks signed, policies signed by the employee, SMT, statement of main terms, contracts, make sure that is all done as part of the first day or the first week. An employee or worker who has not been given a statement or who thinks a statement given is incorrect or incomplete may complain to a tribunal within 3 months of the employer's failure to provide that statement. So it's really important we're providing that on or before the first day. I would also say that it's really important to make sure that what's being issued to your employees in that first week of that induction process, in that first week of employment, is recorded, whether that's you've got that audit trail, a checklist, whether that's through software, but make sure that as part of your induction processes, you're getting everything signed for restrictive covenants, policies, everything. Handbooks. So there's no specific legislation that says you have to have a handbook in place. However, it is best practice to provide employees with a copy of the handbook at the start of their employment. If you're going to make any changes to it, get it updated, then make sure people are signing it off then. A good staff handbook will reflect the ethos and values of the business, and it may be used as a point of reference for employees on all employment issues such as smoking breaks, things like that. It should be readily available as well. So maybe on your company intranet or kept with where other policies are kept. You might have it in your staff workroom or kitchen area. And a failure to provide your workforce with a staff handbook may result in employees not knowing what's expected of them, maybe not knowing how to handle certain situations because there's no clear guidelines in place. And these misunderstandings and conflicts can be challenging to manage, leading to potential grievances. So the more you can have that transparency with your employees, the probably, I would say, the better your employee relations are going to be. Next, types of contracts. So three main types of contracts that we would have for individuals. So an employee, so those working under a contract of employment, you've got that in place, you pay them through your payroll. A worker, so usually works on a part-time or agency temp basis, and self-employed or independent contractor as well, which would be a contract of services or a service agreement. Employment status is at the centre of both employment law and PAYE, as it determines the employment rights that an individual is entitled to receive. HMRC and common law have developed a number of legal tests to determine employment status. If one of our clients phones us up and talks to us about, is this person an employee, are they a worker, are they self-employed, there's a questionnaire that we will go through with our clients just to look at the span of controls within that individual. The main difference between a worker and an employee is that a worker is not obliged to accept work and the employer is not obliged to provide work. There's no real difference between a contract of employment for a part-time and full-time employee, other than certain benefits will be prorated, such as annual leave, bonus schemes might be prorated. Employees who complete 4 years of continuous service under one or more fixed-term contracts are considered permanent. So if you have somebody who's worked for successive contracts of employment that are fixed term, once you get to 4 years, you would be classed as being permanent. And once you get to 2 years, you're more than likely going to have redundancy rights as well with regards to a redundancy payment. A variety of contracts that you can consider. So within our Bright-based scheme, which we'll demo shortly, we've got fixed term contracts, temporary contracts, job shares, 0-hour contracts, annualized hours contracts as well. So it's important as employers that we understand which contract is the most suitable for that particular relationship with that individual and for the consistency of workload as well. If you do require any help or advice on the type of contracts to choose for new starters, let us know and we can provide that further guidance. I'll now just pass over to Lucy, who is going to talk through our Turbo Talent Navigator and give us a quick demo on there. Let me just share my screen, Lucy.
Perfect. Thank you very much. I'll just accept that, and then you should be able to see my screen.
Brilliant.
Lovely. So there we go. So again, you should be able to see my screen now. So our BrightHR, well, at BrightHR, our Turbo Talent Navigator makes hiring for jobs and your talent simple and stress-free just by taking the headache out of creating and filling job vacancies. So again, this is my BrightHR dashboard. And if you scroll down, you'll find this recruitment tab here. So if you select here, this will take you to the Turbo Talent Navigator. Now, this is an organizational tool, so this is to help you streamline the recruitment process by easily managing those vacancies that you have for the jobs and being able to upload applicants to each person as well. So I can see an overview of my vacancies here, 3 unfilled, 1 filled job, for example, and I can add new ones here or view all jobs from here. But if I go up to the top here within jobs, this will basically highlight to me all the jobs that are currently available that I've put onto the system. I can show the ones that have been filled, and I can just change my view on how best to see that. And then you can add new jobs from here, job title, job description, contract type, for example. You can add experience in years, it's completely up to you, and you can show pay as well, but you can also choose to not specify that. I'll explain why that's kind of important in a moment. Now, if I just click into this job here, because I have 2 applicants for this one at a offer level, another at final stage interview. I can see the job info that I put in here. And again, I can view files, I can edit each person, I can add a new applicant, and it only asks for required information being first name and last name. And the source, you can put where that person has contacted you from in regards to the job as well. Now, if I just go back a step, and if I click into Sarah, I can leave notes, as many notes as I want against Sarah. I can view the activity from when she applied to what I've changed the stage to. And I can also upload 5 files per person, so that's including CVs, your cover letters and portfolios and things like that. Now, if I change this stage, this is a recent development that we've had in the system. If I change this to hired instead, it's like a full journey solution, if you will. So, excuse me. So they're just asking, are you hiring, Sarah? Congrats, create an account for this applicant. So what we couldn't do previously is once you'd hired someone, you couldn't then link that information to go straight to the adding them as an employee to the system, but now we can. So if I click yes, create an account, again, it would just take me through that whole setup. So again, that's like a full journey from adding the applicant against the job to now having them added to the system. And then we've also got permissions. So this is why I was explaining before, just that you don't have to show the salary, because you can allow other people to have permission and access the recruitment section within the system. All admins will see it anyway, but if you want certain managers or even employees, because they may be working on recruitment, to access this, you can do it in here. But again, they will see all the jobs that have been added into here and the salaries if you have included them. So that's why we've just allowed to have those restrictions in there if you didn't want them to see that kind of information. And then if I come back to my recruitment, it was also support in terms of some downloadable templates and some support. So you've got job description template, handbook for holding a recruitment interview, and an offer letter as well. So you can download all them to support you, as well as having Bright Lightning at the very bottom. If you're unsure what Bright Lightning is, it's a AI question bot support tool that you can ask about recruitment, and that'll give you that support. So you can just start free typing into here. The Bright Lightning, it's not just available through here. It's not just a tool to use about recruitment. You will also find it on your dashboard as well, just here. So you can use Bright Lightning in all aspects of HR in terms of asking it those questions. But in addition, if you would like to speak to any of our experts, you can call our advice line as well. For example, if you need additional support or advice during recruitment processes, again, our team are on hand to give you that guidance and can act as a sounding board if you're unsure of the steps that you need to take. Maybe you've never done it before. And again, as I mentioned, Lightning can be found on your dashboard to use as well. But if you would like more information on the Turbo Talent Navigator for the recruitment, again, just let us know in that QA box. If there's any kind of questions at all that you've got, pop them in that QA box and we'll make sure we get those answered for you. But what I'm just going to do, I'm just going to pop you back on to Warren. There you go.
Cheers. I would say as well, a really good demo of Lightning there. There was 11,000 questions in Lightning, and they cover HR and health and safety as well. So really good tool for us. We will always talk to our clients about it when they phone us up and ask us a question about statutory maternity pay, as just as a reminder, because it's such a fantastic way to get a quick response to less complicated questions, I would say. But we always welcome calls from clients. Number 2 on our list is health and safety. Health and safety and HR do go hand in hand. And according to Health and Safety Executive UK, stats show that each year over 1 million employees are injured or made ill by their work in GB in Great Britain. As an employer, you've got a duty of care to your employees and must provide a safe working environment regardless of the work that's been undertaken. So we need to look at what we can do to reduce risks, and some considerations to safeguard our businesses are risk assessments, which are used to identify potential hazards and outline the steps taken to reduce that risk occurring. Accident and near miss reporting as well, keeping a record of all those incidents. Having things like adequate toilets, washing and rest facilities as well, making sure they're provided, and access to drinking water. Suitable first aiders as well, and facilities, equipment being available for people during the workplace, nominated first aiders, making sure that you're aware within your business who those first aiders are, and making sure that training is updated for those first aiders. Health and safety policy as well, which we'll touch more on later in regards to policies. However, a health and safety policy is a legal requirement for most businesses. We do offer BrightSafe as a service as well, which I'm sure you are aware of. The software and advice will help you to safeguard your business and protect your employees. It also comes with an app, which is great for managing health and safety when you're on the go, especially if you work between multiple sites. In addition, we've got e-learning courses as well for you to upskill yourself and your people within your teams, and all of which are ROSPA and CPD accredited. For more information on BrightSafe, do let us know in the Q&A box, and we can obviously arrange a free one-to-one demo for you as well. Insurance provision. So Employer liability insurance is compulsory by law. Your policy must cover you for at least £5 million and come from an authorised insurer. And you can be fined £2,500 every day that you're not properly insured. You can also be fined £1,000 if you not display your liability certificate or refuse to make it available to inspectors when they ask. It's a basic legal requirement. However, you may wish to further safeguard your business with additional insurance, such as Bright Safe Insure, and this provides you with an extra layer of protection that will cover your legal costs if the worst happen and you face enforcement action. So say a local enforcement authority like the health and safety exec takes you to court over an accident at work. If you meet the terms of your policy, Bright Safe will will cover all your legal costs and expenses, putting your mind at rest so that you're not going to go out of business. Key one in this session, policies. So a policy outlines standards of good practice for the employee, the employer, or both to follow as well. So things like grievance processes might be outlined, and disciplinary processes might be outlined as well. They can be effective in controlling employee behaviour and help to clarify the official company stance on numerous matters, acting as a guide for managers, as we said, on how they should deal with a particular issue. Policies are really the foundation of the employment relationship, so getting them right and having good, clear policies in place is the key for success. It's advisable to review them regularly, so we would usually say every 12 months to make sure that they are legally compliant. Ones to have, definitely grievance and discipline. So all organisations, no matter what size, must have a grievance and disciplinary policy. Ideally, they should be separate policies. Health and safety policy, as we said before, which is going to set out your approach to health and safety, explaining how, as the employer, you're going to manage health and safety within the workplace, and it should clearly say who does what, when, and how. Data protection policy ensures that you're compliant with GDPR, and if you need to upskill yourself or your managers, we've got e-learning courses on data protection through BrightHR. Another one that we think is certainly important, equal opportunities. So equality, diversity, inclusivity. In order to meet your obligations under the Equality Act from 2010, having a well-defined equal ops policy is key in setting good standards and outlines your commitment to equality as the employer. Other ones as well to consider: sick leave, sick pay. Employees need to be aware of their sick leave and pay entitlement as well. So is it statutory pay for sickness? Is it something more enhanced than that? Is it a company sick pay scheme? Does it change with the length of service up to a maximum of 5 years, 10 years? What is it? So a sick leave pay policy is advisable. BrightHR can support you whether you're looking to implement new policies or whether you want to review existing ones. And Lucy will just show us now a little bit on Brightbase so you can see the kind of policies that we have in there and documents.
Thank you, Warren. Before I do that, I did have a question for you. Give me 1 second just to grab it up. So just from Kieran, so thank you for your question, Kieran. Just asking, if an employee doesn't sign their contract and been in post for a number of years, is it a deemed contract?
I would say it's implied. I would try and find out why they hadn't signed it, if they just forget about it. But I would make sure, as part of an audit, that you've gone through people's files, that you've gone through their records, and you've issued out that contract again to that person. Probably advisable to say do it through email, so you've got an audit trail that it was sent to that person. If they've got any queries on it and say, well, my hours have never been right, or I thought I was going to get more annual leave, have that discussion with the employee, rectify it, or keep with what is in the contract, but make sure that contract is signed, I would say. But yeah, if they came back and said, oh, I don't think I'm being paid correctly, well, why is it taking so long for them to say that, So, but a contract should be there for everybody. So if you notice one isn't there, go through and produce one and issue it to that employee with that audit trail. Good question.
Perfect. Thank you very much. So you should be able to see my screen again. So as we have just discussed, that having access to the right documentation can help you streamline your HR processes. So Brightbase is our library which will act as your HR manager's home for practical tools and documents. So again, Brightbase is located on your navigation bar on the left. So you've got documents and then you've got Brightbase just at the top there. So as you can see when I open it, there is a wealth of documents. There's absolutely loads in here, but they include things like policy templates, fact sheets, guides, letter templates, and much, much more. But finding documents within the library is quick and easy. For an example, if you want to find a policy, you can just use the filter and choose policy documents. Um, you've also got the option to search, such as if I wanted like a data protection policy, just type in data and there it is, and I can use that straight away. And it's super easy to download. You click onto it, download, and you just make any amendments that you want from there. So obviously just to fit you, your company, and what you need to go into that, or what information you need to go into that. But we are continuously updating the documents within Brightbase as well. They're always compliant with changing employment laws, and we're adding new documents too as well when it gets requested, and just all the time anyway. If you want to check out what has recently been added, we do have the what's new filter as well. Get rid of data. There we go.
That worried me when nothing came up.
No, so you've still got a big list of all the new bits in there as well. Um, and then also within Brightbase, not to be confused with the e-learning courses we have under documents, we have some e-learning courses in here that are available to the admins of the system, and within the settings you can make it available, but it would give them access to Brightbase documents as well, to your management. So this basically in here is to upskill management, your admins, if you are having any issues, and again, if you can like managing investigation and disciplinary, or redundancy, or restructure, how to make your business case. These are all things obviously to support those higher levels where your other e-learning courses cover everybody. We also have, if you require something more bespoke than the templates that we have within the document section, we have basically a service called Brightbase Plus. This is where you can get support from our HR experts, but this allows you to work closely with them and make something more bespoke to you and your business. And then Warren did mention BrightSafe earlier in the session. So just to give you a sneak peek, this is my BrightSafe dashboard. So within BrightSafe, you'll have additional documents library, which again is on the dashboard in here, with loads of health and safety documentation like checklists, posters, toolbox talks, checklists. Honestly, I think I've already said checklist, but there's absolutely loads of different things in there available. And then on the dashboard in here as well, you can create risk assessments, accidents and near misses in there as well. You've also got the access to contact the health and safety team for more support in there too. But again, any more information, whether it's on BrightSafe for health and safety, if you were unaware that that was something that we could provide, Brightbase Plus, anything like that, if you're unsure about it and you want a demo or you want to discuss it more with us, pop it in that QA box and we'll get that sorted for you, no problem. Now I am going to provide Warren, I'm just going to give you back the sharing option, but I do have a poll before you
Cheers.
continue. So let me pop that on the screen. This is just for us to get a bit better understanding of obviously the people that attend the webinars, what kind of support you may need. So that is going to be on your screen just now. Again, feel free to get involved. How confident do you feel managing upcoming employment law changes? Very confident, unsure, or I need help. Again, it honestly doesn't matter which one you choose, as long as obviously you're honest with your answer, just so it gives us a better understanding. And then again, let us know in the QA box if there's any current challenges that you're facing. You might have a question on for me, for Warren, or you might want to do something more of a one-to-one basis. And again, we can get that set up for you. That's no problem. So I'll just leave that running a little bit longer. 5 more seconds and then I'll close it down. So if you haven't voted, just pop your vote in now. Okie dokie. So I'm going to close that up and share. So you've got 6% saying very confident, which is excellent, 50% confident, 38% unsure, and 6% I need help. So again, that 6%, And even the unsure, so the ones at 38%, pop it in the QA box because again, we can support you with anything that you feel unsure of, or it might be that you actually have everything that you need, but you just need that clarification. And again, if you are in that 6% where you're saying, I do actually need help, again, that's just what we're here for, so we can support you with that. And anyone in very confident, obviously, if anything ever changes, a new employment law comes out, and then you're unsure of that, at least you know that we are here and we can support you with that too. But I'm going to hide that from the screen and then pop you back on to Warren.
Cheers, thank you. I was just going to say, I spoke to a client last week actually about she wanted to change job descriptions for somebody on her team. She wanted to adapt it, review it, and we were going through the process about how to do that and get the person on board with it. And then we were talking about the number of job description templates that are in Brightbase that she wasn't aware of. And I said, if you just walk through, and I just walked her through it about how to find them. I said they're not finished, they're not 5 pages long, and you can adapt them, you can add them in, but it's a really good foundation to start with if you want to make that start with changing someone's role and looking at that. So really good tool to have. I mean, there are 90 job descriptions in there as template editable documents for clients to use and adapt. So really useful. Um, Number four, compensation and pay. So from April this year, the national living wage increased to £10.42 per hour. Rates for younger workers also increased. If you are unsure of any current rates, as Lucy said before, Lightning has got all the information on those current rates that you see on screen. It has really quick answers, really rapid, 11,000 questions and answers in there as well. Statutory sick pay also increased to £109.40, and statutory maternity, paternity and adoption leave also increased to £172.48. We've also had confirmation of changes to paternity leave, which hasn't changed for at least 8 years. And these changes aim to make it more flexible. So it will include things that currently if you wish to take 2 weeks, you've got to take them together, or you lose the second week. That will change, allowing the person to take the second week at a later date. Currently, leave must be taken within 56 days of the birth or adoption, and that will change to allow leave to be taken at any time during the first year after the birth. And finally, you currently have to tell your employer that you want to take leave and when by 15 weeks before the birth. And the law will change so that you need to tell your employer you're entitled to take leave by 15 weeks before the birth, but then you only need to tell them the dates of your leave by 28 days before you want to take it. So some changes coming through there. We've not yet had written or any confirmation through when those changes will come into play, but it is something just to be prepared for and consider if you are reviewing any of your policies. What happens if you fail to pay national minimum wage? It was in the news in June, early July. So if somebody has not been paid national minimum wage, they can complain to HMRC. And deductions for equipment uniforms must not take an employee below the threshold for national minimum wage. A failure to pay national minimum wage can result in legal proceedings and a fine of up to £20,000 for underpayment of wages. And the Department for Business and Trade publish a list, which we always say is naming and shaming businesses that fail to pay national minimum wage. And featuring on that list can highly damage your reputation. There's some high street names that were on there recently as well. The last one was issued on the 21st of June this year, and 202 employers were named and shamed by the government for failing to pay workers national minimum wage. And they were fined a total of almost £7 million for breaches investigated between 2017 and 2019, with over 60,000 workers being underpaid. And if you look into that, a lot of that is to do with birthdays, people going up through those tiers, apprentices, birthdays, things like that. Certainly something to look out for with whoever runs your payroll. Equal pay and gender pay gap reporting. So according to TUC analysis, women must work for free 54 days compared to the average man. So this means that many women wait until the 23rd of February each year to begin earning a wage equal to their average male colleague. In almost half of the companies and public bodies, male employees are paid at least 10% more than their female counterparts, and only 1 in 10 businesses pay female and male employees equivalent wages, according to The Guardian earlier this year. Equal pay is an important piece of employment law. If an employee can show that their comparator is paid more favourably than them, they can bring an equal pay claim to the tribunal. Under the Equality and Human Rights Commission recommendations, employers should implement an equal pay policy, which you would be able to download a template from Brightbase in our library. And the Equality Act from 2010 legally requires organisations with more than 250 employees to produce a gender pay gap report. However, smaller businesses are encouraged to still do that if they want to do. It's good practice to do it. According to a report by The Guardian, the gender pay gap is closing at a snail's pace, their words, and at current rate of progress, it will take more than 20 years to close that gap. The construction, finance, and education sectors show the biggest gaps in pay. In 2022, the Government Equalities Office announced a new pilot scheme to improve pay transparency. Participating employers listed salary details on job adverts and stopped asking about salary history in their recruitment processes. So it's something you may wish to consider adopting as part of your recruitment strategy moving forward. Recent trends are showing that younger generations entering the workforce are more concerned with their organisation's ethics and values rather than some of the fancier perks that you get with regards to free beer on a Friday. Therefore, having equal pay policy and actively taking steps to close that gender pay gap may result in more success during your recruitment processes and attract more people to your vacancies. Employment law update. So staying up to date with changes in employment legislation is important. It helps your business remain legally compliant and avoids those tribunal claims. Since leaving the EU, we are seeing many changes to existing laws in addition to new ones making their way through Parliament. Just a few of these that you may want to familiarise yourselves with. So first one, Employment Allocation of Tips Act from 2023, especially relevant to hospitality. Employers are legally required to pass all tips and service charges to their workers. A record should be kept of how tips are being allocated. Employees can make a claim and receive up to £5,000 worth of compensation if their employers are getting this wrong, and this is likely to be implemented in April next year. Carers Leave Act, another one coming through. So employees with caring responsibilities will have a legal right to take 5 days off each year. These days will be unpaid and taken as full or half days, and this is again likely to be implemented around April next year. Neonatal Care Leave and Pay Act from 2023. So parents of babies who are admitted to hospital in the first 28 days of life will get extra time added to their maternity or paternity leave. A maximum of 12 weeks can be added, and this is likely to be implemented in October next year in 2024. And then finally on there, Protection from Redundancy, Pregnancy and Family Leave Act from 2023. So pregnant employees and those returning from maternity and adoption must be given suitable vacancy alternatives during a redundancy exercise. And this is for 18 months after the birth or the adoption of the child. It would be unfair dismissal, and discrimination would apply if these employees are not favoured above other employees. And this is likely to be implemented by April next year. It's recently been announced with regards to strikes that once again it will be illegal for temporary workers to replace striking workers. This is effect from August this year. So that's been in the news as well. Bullying and Respect at Work Bill, a new piece of legislation that would introduce statutory definition of bullying. It's likely going to result in an increase in regulation for employers and could potentially increase claims. So it's important to be aware of those changes. Training should be provided to employees and managers on the prevention of discrimination, harassment and bullying. We've got e-learning on things like assertiveness and equality, diversity and inclusivity, which will help with that. What does this mean for employers? So policies are going to be needed for carers, neonatal leave and tips policies for those in hospitality. Related policies will also need reviewing and updating, such as maternity leave. Current redundancy policies and procedures will need to be reviewed to include the extended protection for new parents. And hospitality employers will need to know what the government standard on fair allocation of tips is, as they may need to change practices to comply with that legislation. A failure to make these changes to your within your business may mean that your documentation is no longer legally compliant, and again, that is going to potentially put you at risk of any claims from a tribunal. You're going to have to deal with a grievance first of all, then a potential claim through tribunal. So, a great way to stay up to date with those in changing employment laws and those topics is to check out our HR Heartbeat blog, which is on the BrightHR software. It can be found on our website, social channels, and it's also accessible via our Bright Advice app as well. Holiday entitlement. So almost all employees and workers are entitled to statutory paid annual leave under the provision of the Working Time Regs from 1998. This is from the time they start work with the company, regardless of whether they're part-time or full-time, fixed term or 0 hours. A full-time employee is entitled to a minimum of 28 days paid annual leave, which is the equivalent of 5.6 weeks, and may include public holidays. Part-time employees are entitled to receive a pro rata amount of that annual leave. Rolled up holiday pay. Currently, holiday pay must be paid at the time holiday is taken, and rolled up holiday pay is where holiday pay is added onto hourly pay and paid in each pay slip. It's particularly useful for employers with ad hoc workers, such as those on 0 hours contracts. Recent announcements have confirmed that this will be made lawful again. However, we're yet to receive a date of when that will be implemented. Touching on Harper Trust and Brazil, so in January of this year, the government announced plans to review and potentially reverse the impact of this case so that the 12.07% accrual method would become lawful. We're waiting for that to come through as to whether that will change back to the 12.07%. For the time being, obviously, we will follow the current guidance through the Supreme Court. Enforcing annual leave is something that we get asked quite a lot about. Contrary to popular belief, staff don't have the right to take annual leave whenever they wish to take it. Employers have the right to turn down and refuse annual leave requests. In addition, they also have the right to enforce the take-up of leave as well, so you can force leave on people. An employer must provide double the length of enforced leave as notice. For example, if you wanted somebody to take 2 weeks leave, you must give the employee 4 weeks notice of that. If you have periods where annual leave cannot be taken or periods where you're shutting down, such as Christmas closure, and employees are required to take leave, it should be communicated out clearly with your staff through a policy and making sure people have got enough annual leave to take that over that Christmas shutdown period. Christmas may seem like a lifetime away, although with the weather as it is today, maybe not. However, it is best to get prepared early, avoid disruption, and communicate to your staff in really good time if you are going to enforce that shutdown over Christmas, especially if they're going to have to take it out of their existing annual leave allowance. Managing annual leave is a common challenge business owners face. Our BrightHR software takes the stress out of holiday and rota management, and if you would like a demonstration, then we can obviously show you how we can streamline your processes. Let us know through the Q&A box. Working time. So working time regulations protect health and safety and well-being of employees, and it regulates the maximum weekly working hours, breaks, rest days, and holiday entitlement. Working time by law is defined as when someone is in the employer's disposal or carrying out work or activities or training. So it includes things like being on call. So if you've got a hotel manager who may be available to guests during the night, traveling to a customer or client, such as a traveling salesperson. But working time doesn't include things like routine travel, such as your commute into work, rest breaks, traveling outside of normal working hours, such as for a conference, or training that is not work related. By law, employees and workers must not work more than 48 hours a week on average. This is usually averaged over 17 weeks. However, the rules are different for younger workers. Calculating the weekly working weeks can be done by adding the total hours the employee works in a 17-week period and then divided by 17. Limiting the hours people work is important for everyone's health, safety, and well-being, and being aware of who's working above that average. A failure to comply with working time regs can result in tribunal claims, and an employee can opt out of the 40-hour working limit by signing an opt-out agreement, which is available in Brightbase. However, the employee can cancel this agreement at any time with appropriate notice, and employers should also consider well-being, and working over the 48-hour working week could result in burnout for your employees. If an employee has not opted out and worked more than 48 hours in a week, they must work fewer hours across the calculation reference period to even out the average working week. It's important to keep a record of hours worked, including overtime, and it's something you can do really easily with our BrightHR software. It includes the clocking in and out app called Blip, which makes it really easy to see who's working on shift, where, and when. Pre-employment checks, so looking at right to work in the UK, right to work checks can be completed manually, digitally, or through the Home Office online checking service, and checking relevant documentation such as passport, working visas is key in this process. A failure to comply can have serious repercussions for the business and may result in hefty fines and even criminal prosecution for more severe cases. Checking employment history, so questions we get asked quite a lot about can we check references on current and former employers during the recruitment process. The applicant's consent must be obtained before contacting any referees, and when offering a job, before references have been obtained, a conditional offer should be made to avoid any breach of contract if the offer is withdrawn following unsatisfactory references. And your wording will generally say this is subject to. Something else we get asked a lot about is medical checks. Employers can rely on medical questionnaires to determine the health and well-being of candidates during the recruitment process. Where proof of fitness is required to do the job, it should be made clear that the offer will not be confirmed until the employer has received that medical report confirming fitness. But be mindful about any discrimination claims here. You would definitely ask for that to be filled out once you've actually made that initial offer. You would obviously work through with people as well if they did divulge something, they've got asthma, say, something like that, about any support, any adjustments, what can they can't do. But do be careful if you're going to potentially discriminate and pull an offer because somebody isn't fit enough to do the role. Criminal record, so employers who require more detailed checks, so education, nurseries, early years, can request access through the Disclosure and Barring Service, DBS. DBS checks prevent individuals who are known as a risk to children or vulnerable adults from working with them. Our CEO, Alan Price, recently wrote an article providing guidance for employers on how to handle applicants with a criminal past. On the police, national computers, apparently more than 10.5 million people in the UK have a criminal conviction. But actually, 68% of these are for minor, one-off offences. Yet, when people with criminal convictions are applying for jobs, many have to tick a box and say so. And in the eyes of some employers, this marks the end of the road for that application. Criminal convictions should be approached with care and sensitivity and not judgment, and it's unlawful for employers to treat ex-offenders less favourably if they've got spent convictions. Ending employment. So there are reasons why an employment contract can be terminated, including redundancy, resignation, retirement, dismissal, and we'll briefly touch on these. However, if you would like more detailed information about terminating employment contracts, let us know in the Q&A box and we can offer some further support. So resignation, employees are entitled to terminate their contract at any time, making sure they're given sufficient notice in line with their contract and terms and conditions. There's no obligation by law to give notice in writing, and there are two types of notice, statutory notice and contractual notice. So statutory notice is if an employee is employed for 1 month or more, they're obliged to give a minimum of 1 week's notice. That would then escalate. Contractual notice, if the time specified within their employment contract, you could have it's 1 month from day one. You might get to once somebody's confirmed in post and then make it a month's notice. For some positions within your company, you might have 3 months notice because they're a key manager within your business. During this time of notice, you may wish to issue garden leave, which means an employee is not required to carry out work during their notice period. And it's often used when an employee is moving to a competitor. Once an employee gives their notice, it cannot be withdrawn unless the employer agrees to it. Resignations can be contentious, it can cause disruption within the team as well, and BrightHR through the advice team can offer 24/7 support on advice in dealing with difficult situations. What to do when somebody refuses to work their notice period, what to do when somebody doesn't hand back their uniform, what can you claim back from them. Redundancy is another fair reason to dismiss. So an employee may be dismissed as redundant when a business closes or if their work has ceased or diminished. When considering redundancy, it's really important to build a strong business case, establish that pool for selection. Use objective criteria for selection and apply that fairly and consistently. You want to make sure that you're consulting with those that are at risk of redundancy to ensure that any dismissal is fair. Try and find suitable alternative roles within the organisation where you can, and grant reasonable time off, paid time off, for people that are seeking new work once they've been confirmed of being made redundant. And then finally, obviously, make sure that any redundancy pay for those that qualify that have got more than 2 years service is accurate and is paid correctly. Within the BrightHR dashboard, we've got our redundancy navigator, which is a great tool to support you through what can be a challenging time. And the advice team is clearly on hand every step of the way to provide that support and guidance through each step. Dismissal, so you might need to dismiss an employee for issues. So it could be gross misconduct in that dismissal, which would be a serious breach of contract. It can be a one-off incident such as violence or theft. Continuous misconduct as well. So somebody might have had a series of warnings because of lateness, and then they're at that final warning stage and they've been late again, which is a build-up of conduct issues. Capability is a fair reason to dismiss. So this refers to somebody unable to fulfill their duties or role. Dismissing an employee has lots of risks associated with it, so the correct procedures must be followed to ensure that we don't expose ourselves to any claims coming through a tribunal. Again, something that we deal with on a day-to-day basis and provide that expert support through the advice team. Number 10, managing workplace conflict. So conflict can arise between employees when they've got different points of view, when they communicate in different ways, and it is human nature for people to think and act differently. But it can also lead to personality clashes, especially when we're spending long periods each day working closely together. ACAS estimates that workplace conflict costs UK businesses £28.5 billion per year, and that's approximately £3,000 per individual involved in workplace conflict. Navigating those difficult conversations within the workplace can be a challenge for any manager or team leader. During both grievance and disciplinary procedures, employers may expose themselves to potential discrimination claims if they fail to manage processes correctly. So this includes taking appropriate action once a grievance is made, following your internal policy and procedure, meeting with the employees involved, getting a full picture and scoping out the situation, and conducting a proper and fair investigation, reviewing all the evidence, which might include things like CCTV and obtaining witness statements. You may wish to provide additional training for managers to ensure that they're aware of the correct procedures and to make sure they've got the right skills to deal with difficult situations before issues escalate to a tribunal. Bright e-learning. So at BrightHR, we've got a wealth of e-learning courses, and some are specifically designed to support team leaders and managers, as Lucy demoed before, to improve their knowledge and skill set, so they've got the confidence in dealing with those difficult conversations. Steps you can take to reduce workplace conflict. So promote that positive workplace culture to reduce any claims, listening to your employees, maybe doing some anonymous surveys, zero tolerance stance towards bullying and harassment, so make sure your policy reflects that. Thinking about maybe having mental health first aiders in the workplace as well. That clearly promotes that you take it seriously and you are recognizing that if people need support, you've got support on hand. Our Director of Service, Jenny Marsden, recently wrote an article for the HR Director providing managers with her top tips to start difficult conversations in the workplace. And Jenny says that conflict is not necessarily damaging. If managed correctly, conflict can actually pose an opportunity to understand opposing preferences, points of views and values, and instead it can generate ideas. That said, though, it can be difficult to navigate through those situations, and managers might be scared of saying the wrong thing or stirring up further conflict, which is where the management training will support your team to give them confidence to handle those situations correctly. Workplace stress, so a large aspect which can cause friction between employees is dealing with stress, both work situations and personal life situations as well. And Lucy's just going to talk us through now some guidance on wellbeing and counselling through our employee assistance programme.
Thank you, Warren. And there's no demo for this one, so I don't need you to send that over. So an employee assistance program, so that's the EAP. is a confidential advice service for employees. So, access to an EAP can be provided as part of the employee's benefits package and is designed to help employees deal with personal problems, whether they are work related or not, to be honest. This includes financial issues, family life concerns, matrimonial issues, and general worries or anxiety. So, telephone advice, face to face counselling, and online programs can be included. REAP, so Bright Wellbeing and Counselling, brings your staff a wealth of wellbeing services to support them through life's changes, basically. And it's provided by Health Assured, who are the leading employee assistance programme in the UK, which offers specialist support to over 15 million people every single day. This also includes 24/7 helpline, so that's available 365 days of the year. I said last week that, of course, someone will answer the phone on Christmas Day. And a lot of the time, that can be a really hard season for people as well. Available to staff and their immediate family. Skip long waiting lists for therapy. And they also get an app. So it's called, they're able to download the My Healthy Advantage app for personalised content on the go. And then there's 85% of employees in the UK have said that they're more likely to be loyal to their employer if they support them during the cost of living crisis. So this obviously highlights the importance of having something or considering an EAP within your business. Um, that's everything from me in terms of EAP, to be honest, Warren. I think I'm just popping back to you now for the summary.
Yeah, thank you. So just to summarize, we've covered many topics in today's session. I know there's a lot of content in there, but I think key takeaways are getting your documentation in place is key. Using Brightbase to help with that can support you and your managers with those essential editable documents, fact sheets, templates. Managing annual leave can be challenging for many small businesses to navigate, but having an annual leave policy will ensure your employees understand their holiday entitlement and the process for requesting annual leave as well. And a software system like Bright makes it really slick and easy. Employment law is constantly changing. It's important to stay up to date with new and changing laws to make sure you're legally compliant and avoid any hefty fines. And there's lots of things we've run through today with regards to where you can get that support and advice from. Just some final next steps before we finish today's session. You will get a webinar survey, which is 7 really quick questions. If you could answer that, it takes all of 30 seconds. That would be great. It helps us to plan future sessions. It helps us to review our content and delivery. If you visit www.brighthr.com/webinars to view our free on-demand library and upcoming webinars, they're all on there. So the previous ones that we've done are in there. And a recording of the session today will be sent to you as well. I think this is your bit, Lucy.
My turn. I'm here.
I always just stop at that point and just think you're going to pick it up. I should always say, Lucy, you're going to run through demos.
I'm
Sorry.
here. I'm here. Don't worry. So during today's session, I've given you obviously a brief outlook of Bright HR and the amazing features it provides, but unfortunately I don't have time to go through absolutely everything. Um, if you would like obviously to hear more, you can book the free one-to-one call with us. Just again, whether it's anything Warren's discussed, I've discussed today, that's fine. I can already see people that have been booking in slots, which is great. We've got some left today at 2, 3, and 4 p.m. Just let us know again in that QA box if you're happy to take one of those slots for today. If you are unavailable, that's absolutely fine. We can work around your schedule as well. So again, just let us know when's best for you and we will get that sorted for you. And everyone in today's session, again, will receive a follow-up call anyway, just to get some feedback and see if there's anything else that we can support you with and show you how to access any support materials. There's been a lot of questions today, so I appreciate that not everybody has had theirs answered from myself or Warren today, but you will get a follow-up. We will make sure that your question, sorry, is answered after this session. Now, what we'll do is we'll just keep the session running for a little bit longer, just so you can book in for your one-to-one sessions. You can put in some last-minute questions, and then again, like I said, you will get contacted in regards to those. But thank you very much, everyone, for joining today, and hopefully we'll see you on our next webinar series.
Thanks for attending, everybody. Thanks for your input as well. And like Lucy says, we will answer those questions. We will come back to people as soon as. Thank you.
Thanks, everyone. See you later.